Good afternoon, ladies and gentlemen. This is our last time to speak with you. The prosecution has the burden of proof. We'll go into that, but that's why they get, in a case like this, the last say. So this is the only time, that I get to speak to you. I want to thank you on behalf of Linda Stermer and our team for the attention you paid throughout this case. Everybody took notes and asked question after question after question. So I know you're paying attention, so thank you. I want to tell you a little bit about your job. When you go back to the jury room, you actually have 3 jobs back there. One, obviously, is to decide the facts of the case and how they apply to the law. The second job you have is to make sure that everybody on this jury follows the law. And when I say follow the law, when you were sworn in and we selected the jury, a lot of questions about the presumption of innocence, the burden of proof. As Linda Stermer sits here today, she is innocent. As Linda Stermer, when you go back into the room, when you walk through those doors, she is innocent. That is a solemn oath you took to hold that throughout this case. The third job you have when you go back there is to explain your position to the 11 other people on the jury, how you saw the evidence, what you thought about, how you considered it, and to also listen to them fairly and make sure that everybody gets their word. When you follow the law, what I'm saying is you have a right as a juror to make sure that when you go home after this case, everybody followed the law. Nobody bullied anybody else into trying to cave their opinion without following the law about presumption of innocence and the high burden of proof beyond a reasonable doubt. You heard Ms. Zuderveen speak for an hour and a half, and I timed it. She spent 5 minutes on the fire and the cause of the fire. So let me tell you what this case is not about. This case is not about a van impact. You heard Dr. Markey on a witness stand. Dr. Markey and Ms. Zuderveen said what she thought Dr. Markey told you. The one thing that Judge Brickley will tell you is what we say here is not evidence. What you heard from the witness stand, that's evidence. That's what you consider. And I'm sure Ms. Zuderveen didn't intend to misrepresent anything, but she didn't have a transcript of his testimony like I do, like we purchased. So I want to tell you what Dr. Markey said in terms of the cause of death. On page 19, Dr. Markey said to a question, my question. Well, let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries. Fair? Said, yes, I believe his death was caused by the thermal injury. Dr. Markey's opinion is the official medical opinion in this case. It's undisputed. And the government, the state, with all its resources, couldn't find another doctor in the state or in the country to say that the van impact had anything to do with Todd Stermer's death. It was solely caused by the fire. And Linda Stermer has not been charged in this case with anything having to do with a vehicle impact to Todd Stermer, not even a misdemeanor. So what does that tell us? One, the van didn't cause the death, and the van certainly didn't start the fire. Why did they spend so much time on the van? Well, I'll tell you. Because they wanted to distract you from the fact that they have no evidence of how the fire started. This case, ladies and gentlemen, the charges are first-degree premeditated murder. Ms. Utterbein showed you the jury instruction and went through a whole bullet PowerPoint. Boiled down to, Ms. Stermer intended to kill her husband, thought about it for some time, and then carried it out. But the carried it out part is she's charged with felony murder. The felony is arson. So if there's no arson, there is no crime. If there is no crime, there is no premeditation. And so when you consider what you need to do is look at two things. Was the fire intentionally set? And if it was, did Linda Stermer set the fire? Those are the simple issues in this case. The burden of proof for the state is extremely high. Let's talk about that. Burden of proof is beyond a reasonable doubt. Reasonable doubt, ladies and gentlemen, simple terms, is doubt based on reason and common sense. If you have any doubt, as you look at all the evidence today that I'm going to show you and summarize the evidence, if you have any doubt that doesn't require you to abandon reason, then that's reasonable doubt. And what is a doubt? Well, remember I explained it with Mr. Leroy. To lack confidence in, to not trust, that's doubt. Here's the burden of proof, ladies and gentlemen. In a criminal case, the burden of proof beyond a reasonable doubt is the highest burden we have in any kind of case. And the reason is because when the government is going to take your freedom, our founding fathers made sure that they couldn't just say, we don't like you, we think you're guilty, and we're going to put you in prison. So what do we do here? Let's look at this. Is there a slight amount of guilt? Not good enough. Is she possibly guilty? Did she possibly set the fire? If somebody says that, you say not good enough. I've done a lot of civil cases where people sue for money, car accidents, product liability. In a civil case, the burden of proof is a preponderance of the evidence. Is it more likely than not that we believe Wolf's side or the other side? Kind of people like to say 51% versus 49. If it's 51%, more likely than not, then plaintiff prevails. That's not this case. Is it probable? Somebody says, I'm pretty sure, I think she probably did it. Not good enough. So when we talk about, as you go back into the jury room, what your lens is, these are the the things you need to consider. Very probable. I think almost for sure she did it. Not good enough. Now here's the other thing. In a civil case, the highest burden we have in a civil case is called clear and convincing evidence. That's not good enough. What does that mean? So when you go and address each other in the jury room, clear and convincing evidence under the law is to be clear and convincing. The evidence must be strong enough to cause you to have a clear and firm belief that the proposition is true. Not good enough. Somebody tells you in the jury room, I really feel she set the fire intentionally. Not good enough. If you have any doubt as you look at the evidence that is supported by reason and common sense, no matter how small, that's reasonable doubt. And your job as a jury is to return a not guilty verdict unless the government, unless the state meets that high burden, exceeds beyond a reasonable doubt. Your job as you go in there, unless they do that, is to return a not guilty verdict. The other presumption, so the presumption of innocence, Your Honor will review the law, and the law says this. we start out with the presumption that where there's a fire, the law assumes that it had a natural or accidental cause. The prosecutor must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You start with the presumption that's an accident. So that's the lens you need to look at as you go through this case. You know, before we started, one of the jurors asked, why would this case take 3 weeks? Shouldn't it maybe take 2 weeks? Because after all, it is only an arson case. Todd Stermer died of a fire. So you just have to decide whether the fire was intentional, and if it was, 2 issues, did Linda Stermer intentionally set the fire? Instead, what you heard, and I counted the witnesses, 20 witnesses over 1 week to talk about the van, to talk about infidelity, to talk about other issues. And why? Because the state wanted to distract you from your job, which is simply to decide, was this an intentionally set fire? And it's interesting, in opening statement, and I had that, everybody took good notes, I'm sure, so you'll be able to go back to opening statement. The prosecutor never said what caused the fire. And here, after 3 weeks, Ms. Zutterveen spoke for an hour and a half and spoke for 5 minutes on the fire. And the best she could do is say that Scott Leroy said the fire was consistent with being intentional. You don't get a conviction based on it would be consistent with being intentional. Experts, as we'll talk about, are held to high standards. There's no guesswork in experts. You don't get to speculate. We'll talk about speculative opinions that Mr. Leroy had and possibilities. You heard from every legitimate expert in this case, starting with the MSP chemist, Troy Ernst. We don't engage in speculation. Speculation masqueraded as an expert opinion is misleading. So that's why we don't do that. Your decision must be based on the evidence. The evidence that is clear, credible, and compelling factual evidence, not speculation and guesswork. So when you deliberate, you start with the assumption and the question, assuming Linda Stermer did not set this fire. Did the prosecution meet its burden of proof beyond a reasonable doubt for every fact it needs to prove to meet those elements, those boxes that she talked about? And if they can't rule out reasonable doubt, if they can't rule out alternate causes, if they can't rule out alternate theories, if you can't rule it out, that's reasonable doubt. And we'll talk about that as we go through this. It's got to be based on the evidence. You know, one thing we heard when you were being selected, and you'll remember this, Ms. Zutterveen, when she was asking you questions, asked you this. It might take, to present all the evidence, we might be here for 2 months. So will you give us a pass? Will you not hold it against us if we don't give you all the evidence? You're darn right you have to hold it against them. They have the burden of proof of bringing all the evidence they have to establish guilt beyond a reasonable doubt. They don't get a pass, and you can't give them a pass because they didn't bring you evidence. We'll talk specifically, but I do remember one thing I wanted to bring to mind. There was that video, remember Deputy Gruss did the in-car video, and they showed 10 pictures over 9 seconds. One of the critical issues in this case, as you remember, is how fast was the fire, the speed of the fire, the direction of the fire. 10 stills over 9 seconds. I asked Deputy Gruss, what happened to your video? I don't know. Don't you think it might be better, since we're talking about speed of fire and direction, if we had the video? Would that help? Yeah, that would help. but they didn't have it. So they can't help you with a critical decision in terms of the speed and propagation of the fire. So when you think about evidence that they say they don't want to show, that they don't have to show, can you give us a pass, don't hold it against us, you hold it against them. So why is Linda here? Why is Linda Stermer, after 18 years sitting in the defense seat? Well, how about there was a house fire, and as soon as the police got there was a man who died, and then there was blood on a bumper. So they rushed to judgment and automatically assumed someone's dead, someone's alive, blood on the bumper, has to be a crime. And you remember Sergeant Leroy, when he arrived on the scene, spent a lot of time telling you about the pictures he took about the bumper, because he suspected it was a crime. He took more pictures that night of the vehicle than he took of the house. He is the state's origin and cause expert. This became a rush to judgment with no evidence. In fact, what it really was, as you will see, this was a prosecution looking for a crime because they worked backwards. Why do you think Ms. Zuderveen spent the majority of her time this afternoon, and the majority of the case, talking about infidelity, talking about having romance and best sex ever, and wanted to run away? Nobody said she wanted to run away with somebody. Chris Williams didn't say that. You can look at your notes. No, they wanted to show you the why, the motive. Remember, she said, we don't have to show you motive, but they spent the whole case and the whole afternoon talking about motive. Because they wanted to show you the why so you wouldn't focus on, how about the where? How about the area of origin? And more importantly, how about the how? Because they can't tell you how the fire started. Sergeant Leroy, when you go through your notes, and I'll summarize it, you will not find anything where he said he could identify the cause of the fire, how the fire started. And if you can't identify the how, and even the where, then you certainly can't identify the who. This was a prosecution looking for a crime, working backwards. And all because they found blood on the bumper. Ms. Stermer, from pretty much the first night, within a couple hours, had a target on her back, a bullseye on her back. She's grieving the loss of her husband, and they make her take her clothes off to give it to them for evidence within 2 hours. Her husband's still there. Remember, you saw the pictures from Sergeant Leroy. He's there at 7 o'clock at night taking pictures of the body. She has to take her clothes off and switch clothes. She had a target on her back, a bullseye on her back, only because there was blood on the bumper, and as Sergeant Leroy said, time of day and 2 able-bodied people, and only one of them survived. And we'll talk about that is no kind of scientific evidence. We're going to talk about the scientific method in a bit. But I wanted to tell you about one thing. As you look and listen to Ms. Zuderveen, one of the things that she was talking about motive was the idea of they were in debt and she had a financial motive and she wanted to get money so they could clear the debts and whatever. Remember what Attorney Willison said, who interrogated Linda Stermer for 2 days? After his investigation, he's a 30-year lawyer, doing nothing but exams under oath, trying to detect fraud. What did he say? And your notes will say this. There was no financial motive. I looked. There was no financial motive. There was no romantic motive. So when you think about what's been said here, it's all about credibility. We lawyers, we hope we have credibility. We hope what I tell you is backed up by your notes and the evidence. But what Ms. Zuderveen told you about a financial motive was completely opposite from what the witness said. It certainly wasn't about romance and sex. Now let's talk a little bit about what Sergeant Leroy did, because we're going to talk about the fire investigation. Remember, we talked about the scientific method. You probably learned more about the scientific method if you're not into science than you ever wanted to. I used to be an engineer, and sometimes it makes my eyes glass. You have to collect the data. Most important step. This is always for these fire guys, figure out the origin and cause. So it really starts with step one here. Collect the data, all the available data that you can that might be relevant to the task. Even Sergeant Leroy said that. All the available data. Remember, witness statements, building records, we'll talk about those. Physical inspection, excavation. Collecting data includes excavation of the property. That's where the gold is. That's where the evidence is. That's where you find the burn patterns and the objects that show you where the fire started and what could have caused the fire. Sergeant Leroy, under oath, and he admitted this, remember this? If you don't collect the data, you can't analyze it. You have nothing to analyze, which means you can't develop a hypothesis, which means you can't test anything because you don't have that, and you can't select a final hypothesis. If you don't do every single step, what did he tell you? You have an unreliable methodology. And if you have an unreliable methodology, what did he tell you? You have an unreliable opinion. It can't be relied upon. It can't be trusted. The very definition of doubt. Garbage in equals garbage out. So we're going to talk about all the various things he did and whether it complied with the scientific method like he said he did, or this guidebook, which every single fire investigator trains to, tests to, and teaches to. NFPA 921. There were some questions about, this is the 2024 version. It's been going on every 3 years since 1992. But the main thrust is you have to comply with the scientific method. The scientific method has been around in the sciences for decades. And so the fact that this was 2007, we're in trial in 2025. The 2024 version is what is in effect, what you have to comply with. And you might say, well, why are you holding the guy to 2024 when it happened in 2007? Because you have to be open to change your opinion based on new developments. And in this case, there are no new developments. It's the scientific method. Collect the data, follow the steps. That's fundamental, was fundamental in 2007, was fundamental in 1992, and has been fundamental for decades before that, the scientific method. So let's look at what Sergeant Leroy did. Sergeant Leroy got to the scene on the 8th, and then under oath, he told you, he went through the building, and he cleared with his friend Greg Stormzan, who you heard from yesterday, an area 20 feet by 20 feet by 2 feet, 800 cubic feet of debris. And what does that debris look like? This is Sergeant Leroy's picture of his area of origin. Oops. Yeah, we are. Oh, should be coming. There we go. What did Mr. Leroy's area of origin look like when he was there? You see this? Right here, that's the first floor fireplace that we've been talking about. Here is a chimney chase that we were talking about. We'll talk about more about that. But here is the 2 feet of debris in this 20 by 20 living room that extends from the fireplace all the way to the bay windows. And what was his testimony under oath to you? Greg Storms and I cleared the entire living room and deposited it outside. And he said my pile was 4 feet by 8 feet by 7 feet high, as tall as Shaq. When you do the math, that's nowhere near an 20 by 20 by 2 cubic feet. That's about 28% of it, if I had a calculator. And what did it look like when the next person came? The next person who came was Mr. McHugh, you remember that? And he took a picture of the back. He was there on the 10th. 2 days after Sergeant Leroy, on the 10th, and he testified, I think it was yesterday, maybe the day before, and all he saw was this. And then Mr. Shinsky came, and Mr. Shinsky came a couple days later on the 11th, and his picture was better. But I ask you, where is this 4 foot by 8 foot by 7 foot high pile that Mr. Leroy said he excavated? Somebody steal it? He actually almost said, I don't know. Maybe. Here's the thing. You remember Mr. Shinsky? He said, I had to come back on the 15th with an excavator because it was too dangerous. So if it's too dangerous for a veteran like Mr. Shinsky, who, by the way, trained Mr. Leroy, then you know Mr. Leroy wasn't doing any excavation of the whole living room floor, and there was no clear 20 foot by 20 foot area. Shinsky's picture, after they came back with an excavator, you remember, here's the fireplace area, and there's the living room, goes out to what would have been the bay windows. Look at all that rubble, look at all that debris. I could basically, and by the way, Mr. Shinsky testified that he did the excavation. How do I know what he exactly said? Because I have his transcript, and we have his words. And his words were, in reference to the structural damage, you would then have to contract with someone else to come out and do the excavation of the house. Correct? No, I conducted that. You did the excavation yourself? Yes. Physically, hand by hand? Physically, hand by hand. And hired an excavator so we could remove the areas of the house that were hanging over the burned out section of the rear of the home so that it was safe to get in and actually do that. And then he continued, how many days did it take you to perform the excavation of the property? He said, I would believe I was there for 2 days. You remember when Mr. Leroy first told you that he looked for his pictures of the excavation and he couldn't find them. And then this half-truth, sometimes you just got to keep asking questions. And then you get to the truth. And then he says, I didn't take any, and I didn't make any reports. His testimony is directly contrasted by Mr. Shinsky's. And what was his excuse? It was a long day. I was tired, and I forgot. You remember I asked him, would you take that answer from somebody you're training? What was his answer? Yes. Well, it depends on the fire. This is a death case. It doesn't get more serious. Like Mr. Stormzan said, you have to bring your A game. Leroy, I can say it in lawyer terms, his story was demonstrably false. But if we want to just be real, he lied to you. And if he lied to you, you can't trust his opinions. Because if you can't trust the messenger, you can't trust the message. So when you go back and you analyze Mr. Leroy's work in this case, think about that. He lied about the very thing he needed to do, step one, collecting the data, so he could get to the conclusions, so he could develop the hypotheses, so he could try to figure out what went wrong and caused this fire. And you know what he said about that? He said, I didn't take any evidence because it had no evidentiary value. You see, there's that half-truth again that Ms. Zuderman has been talking about. You're right, you didn't take any evidence because you didn't look to find any evidence. When you analyze what he's doing, look at it in the terms of his credibility and the high burden of proof. If you have any reasonable doubt about any of his opinions, especially when he lied to you, that's all you need. And when you have one reasonable doubt, ladies and gentlemen, about any issue, your job is done. Your job is done once you find one reasonable doubt. There's only two questions, really. You're going to hear, and I'll tell you about the verdict form and first-degree felony murder, first-degree murder, second-degree murder. It's all about, did she set a fire, and was it intentional? That's it. And you remember, well, we'll talk about it in a little bit, but as I said, one of the jurors was we were talking about half-truths. When my kids, I think they're lying to me, I just keep pressing, and then I get the answer. We kept pressing, Leroy, and then we got the answer. So I want to look at these experts in this case, because this is very important. I brought to you Bob Trenkle. Bob Trenkle is almost a 60-year veteran. Got born and raised in Detroit, cut his teeth in Detroit, literally the murder arson capital of the world back then. He has trained people, taught people, tested, been on committees, and what did he tell you? He spent 2,000 hours in this case, 2,000, over about 10 years. And when I asked him, how much you charge? Like $250 an hour? And then Mr. Blair came up, he couldn't wait to do the math. And he said, I'm not charging anything in this case. I think there was a question. If you're not charging anything, this is America after all. You must have a personal relationship with the family, with Linda Stermer. There is no relationship. He spent 2,000 hours in this case. He knows every piece of the evidence. He knows everything that Leroy did and Shinsky did. Leroy spent less than 6 hours on the scene and developed his report. You know, he spent more time testifying, defending his opinions than he spent on the scene getting his opinions. And when you think about this, these are real questions that need to be asked when you go back to the jury, these kind of devil's advocate, cynical questions. Mr. Shinsky is a veteran, way more experienced than Mr. Leroy, taught Mr. Leroy. Mr. Shinsky was actually at the house, as you saw, same time Leroy was, same week, did the excavation, did an investigation. Why didn't they hire him? Why didn't they hire Mr. Shinsky to come in and tell us how good Leroy's opinion was and his methods? Maybe because Shinsky said, I did the excavation, and he would have known that Leroy lied. And the other thing is, Mr. Shinsky was asked to read this interview. Remember, read nothing but a transcript, bored the heck out of all of us. He's a fire origin and cause guy. He determined the origin and cause. Why didn't they hire him and ask him his opinions? Maybe because he disagreed with Mr. Leroy. And if you think there's any chance that's supported by reason and common sense that Shinsky disagreed with Leroy, that's an intentional fire, and maybe he determined based on all the damage that you can't just get every scene. It's undetermined, like Mr. Trenkle. That's why they didn't retain him. That's why they didn't hire the second most experienced guy who you saw in this case. And you know what? Greg Stormzan was with him. You remember he was his partner on that excavation? Stormzan said, well, you got to document so people can understand what you did. And it'd be the guy who was supposed to, I was just assisting because it's not my jurisdiction. He's the one who's supposed to take photographs. He's the one who's supposed to report. He didn't. You can't just omit this stuff. And when you think about this poor excuse of I was tired and I forgot, did you forget to write a report? Would you forget you were tired when you were writing a report and left out the excavation? Or maybe you didn't do it. Maybe you didn't do what you said you did under oath to us. If there's any reasonable doubt about Leroy's methods, how he failed the scientific method, anything that's supported by reason and common sense, no matter how small, that's reasonable doubt. And when you get one reasonable doubt, you're done. Not guilty. By the way, Mr. Leroy really kind of has an inherent conflict of interest when you think about it. He's up here defending his own work, and nobody's defending him. Like I said, he spent more time in the last 18 years defending what he didn't do than he spent getting the evidence. Follow the science, ladies and gentlemen. When you look at what was done here by Leroy, follow the science, what he collected, what he analyzed in 2007, and not what they're trying to suggest, well, so-and-so backs you up on this in 2024. That's not when he did the investigation and the lack of excavation. 2007 is when you hold him to the evidence that he collected and his analysis. Follow the science, follow the objective evidence. We brought you objective evidence. And by the way, defendant has no burden of proof. We don't have to show you anything. We didn't even have to call a witness, but we did. We called Mr. Trenkle. We called Dr. Z, who said this is a 5-mile-an-hour impact. We'll talk about that as it gets to whether Linda Stermer intended to do anything. But let's talk about the reasonable doubt in this case. Starting with, as I said, Mr. Leroy's conclusions. And so because I didn't want to write it on the board, because my handwriting kind of sucks. Here, Leroy's opinion. Opinions are not reliable. Garbage in equals garbage out. And there was a whole lot of garbage in what he didn't do. You can't trust his opinions because you can't trust his methods because he didn't do it. He didn't comply with 921. He didn't comply with the scientific method. Did Leroy rule out an alternate area of origin? You remember, Mr. Leroy agreed with me, his living room here is about the size of this courtroom, all the way to the bench. Sometimes, as you saw NFPA 921, it says, sometimes the damage is just too much and the area is too big, and you can't make conclusions. You heard Mr. Trenkle. Ideally, you're trying to get to a point of origin. It was the back of the toaster. It was the electrical outlet. The bigger you get, the worse your reliability of your opinions are going to be because they're just too much. And by the way, when you look at this and you're considering reasonable doubt, think about this. I stood here. Could the fire started here? Don't know. Could the fire started there? Don't know. Could the fire started there? Don't know. He can't tell you the where. If he can't tell you the where, you can forget about it. Because remember what NFPA 921 says? If you're not in the right area of origin, you can't find the cause. Because the cause is going to be in the area of origin. But if you don't look, and if you don't excavate, you will never find it. So then we talked about alternate areas of origin. Remember that chimney chase? And Mr. Trenkle said, the chimney chase, you heard from Cassandra Grigg, one of the witnesses yesterday. She talked about, first of all, how everybody talked about this house was unfinished, The whole living room is OSB pressboard, subfloor with a couple throw rugs, and the chimney, the surrounding area, was pressboard. You didn't hear them bring anybody to say it wasn't. They could have asked the two boys. They had them up there today. What about the chimney? They didn't ask that question. There's a reason they didn't ask that question. They didn't want to hear it out of their own witness's mouth. Could the chimney chase reasonably be a possible area of origin? Well, Mr. Trinkle told you it's consistent with the witness reports of a fire from the back rear of the place, flames shooting out of the roof, chimney chase. That chimney chase is 2+ stories high, and if you have a problem in the chimney from the flue, which you saw the rubble, he didn't even analyze, then you can have rubble pouring down, and by the laws of physics, things don't drop straight down. They go in arcs. They fall out and down, in an arc. And when you have a wall collapsing, that would be consistent with getting Todd in the living room. That would be consistent with his burns on his hands. And that would be consistent with a pretty sudden fire and him screaming. So we don't have to prove that it's the chimney chase. We're not here to prove that the chimney chase is where the fire started. He can't rule out the chimney chase could logically possibly be the area of origin because he didn't do the work. And if you can't rule it out, that's reasonable doubt. Let's look at the next one. Gasoline was on sweatpants not related to the fire. Can he rule out that maybe the gasoline he found on the sweatpants had nothing to do with this fire? Well, you remember his testimony? At least he was candid with me, because I had his old testimony from 4 years ago. He has no opinion on whether the gas on the sweatpants had anything to do with this fire. He said, I don't know how it got there. I don't know where Todd was when it got there. I don't know when it got there. I don't know when the last time the pants were washed. I don't know any of it. So finally he was candid enough, because I had him trapped, to say, I don't know. I have no opinion. Well, that's the whole linchpin of his whole gasoline in the house, because he admitted there's no gasoline in the living room. None was found. None. If he can't rule out that the gasoline has nothing to do with this fire, then you have to return a not guilty verdict, because that is reasonable doubt. That's the whole basis of his opinion. I'm sure you folks have notes on that. Now, this is important. The other thing that can cause reasonable doubt is, do you remember when I was asking him about his opinion, he relied on Linda Stermer and her testimony about being in the laundry room and running upstairs when Todd screamed. He was upstairs, she's downstairs. You remember, you heard a lot of talk today about all the inconsistent stories. What you've heard from every single witness who talked to Linda Stermer is that she was downstairs and Todd was upstairs when she heard this horrible scream and he was on fire. And she ran upstairs, and then her world turned upside down. So, my easel finally. Todd was upstairs. Linda forgive me, that's how my mom used to draw her when I was a kid, was downstairs. She was downstairs and had to run upstairs. Even Sergeant Leroy agrees with the obvious, you can't be two places at the same time. That means when he caught on fire, she wasn't there. She wasn't with him. And the interesting thing is, oh, wait. Interesting thing is, when Mr. Blair apparently realized this is checkmate on reasonable doubt and where the fire started and the cause of the fire, he started asking, well, isn't it possible that maybe she could have poured gasoline on him and ran down the stairs and there was all these fumes and she didn't get any gas? She didn't get any gas on her after doing that? Testing to 0.0005, not a drop, not a speck on that high-tech machine? No, there's no such thing as possibility. You heard every legitimate expert say, we don't guess. Because guesswork masquerading as expert opinion testimony is junk science, and it's frankly unethical. We don't do that. So this idea of they'd like to show possibilities, you don't deal in possibilities. You are the judges of the evidence. But the evidence from their expert, I'm not an expert at fire science. You're not presumably an expert at fire science. You have to rely on the evidence that you heard from the witness chair. And the evidence from Leroy and Mr. Trankel was she was downstairs, he was upstairs. She wasn't with him. If there's any reasonable doubt that she had nothing to do with the fire, not guilty is your job. What's another reasonable doubt? No evidence of an ignition source. Let's talk about that for a little bit. Because you don't collect any evidence, he couldn't find any evidence of an ignition source. You remember we talked about NFPA 921 and the causal factors. Causal factors, if you'll recall, you look at your notes, are you have to have an ignition source and you have to have a first fuel. Ignition source, what's the thing that made something catch fire? If you're at first fuel, what's the first thing that caught fire? And most importantly, how did 1 and 2 come together? He didn't have any evidence of an ignition source, so he supplied one and said it's an open flame. Could be from the fireplace, could be from candles, don't know. Well, he didn't rule those out either. And then he said gasoline, but see, this is circular because he said gasoline on the sweatpants, which he's admitted he didn't know how long it had been there, means there's gasoline in the house. That's completely illogical. He didn't have a first fuel. And he certainly couldn't put 1 and 2 together to tell anybody what caused the fire. How did the first fuel, even if it was open flame, 2, gasoline, how did it come together? What's the first thing that happened? Doesn't know. What's the second thing? Because you have to, as an expert, you have to do this. You have to say, this is the first thing that caught fire, and based on our training and experience, we know the fire propagated this way. This caught fire, then it caught that fire, and it caught that fire, and it caught that fire. You tell how the fire started and how the fire progressed. He couldn't do that because he didn't do step 1 of the scientific method. He didn't collect the data. Garbage in equals garbage out. And when there's garbage for the out because of garbage from the in, that's reasonable doubt. Doubt calls into question the confidence in his opinion based on reason and common sense. Reason and common sense tells us you can't be where the fire started if you're downstairs. He couldn't give us the how. Frankly, he couldn't even give us the where because he doesn't know within this huge area of origin where the fire started. Number 9. since he couldn't tell us the cause, he certainly can't tell us the classification. Accidental fires, natural fires, lightning strikes, undetermined, and incendiary. Incendiary is the only classification that supports a crime. And if you don't have a cause, you can't have a classification. If you don't have a cause, the only intellectually honest thing you can do with integrity and honesty is say, it's undetermined. And there's no shame in that. Because sometimes fires are just too total. The damage is just too much. Did he rule out an electrical or mechanical cause of the fire? Well, he's admitted he's not an electrical expert, and he's admitted under oath that he didn't collect anything. So how could he rule something out that he didn't collect? And what does he do? He explains that, well, electrical fires in walls, they start small and slow, and so this is why this whole able-bodied thing comes into play, and an able-bodied person, if it was electrical, could figure that out and escape. Electrical fires in walls can explode all the time. Happens all the time. Did he exclude and rule out a mechanical cause? The flue. You saw all that damage to all the flue pipes. That's why we bring in people and they look at it and they try to see what could have been a failure of the flue, and that's how things started in a chimney chase. He's not an expert, he said that. He didn't collect the data. You saw how Shinsky laid out the stuff like you're supposed to do. What did Leroy do when he was tired and it was a long day? He threw the stuff in a pile in the back of the house. And forget about 123. We'll get it. You remember Shinsky's photo. He just piled it. There's no analysis, there's no thorough investigation, there's no thorough, rigorous testing, which is what NFPA and a scientific method say you have to do. He just threw it out so he could go home because he was tired. And remember I asked, why didn't you just come back the next day? Didn't have an answer for that. Wouldn't you have told your young associate? Nothing wrong with going back, why didn't you go back? And why didn't you write a report? And why didn't you do what you were required to do in this death case? Then he didn't rule out contamination of the sweatpants. Remember, he found 3 hours later Todd Stermer, and he smelled gasoline. We'll talk about that in just a second. He smelled fuel. I shouldn't say gasoline, because he said, at least he was honest, fuel is fuel when you're smelling it. I don't have a super nose. So he smelled fuel, and that's why he took the sweatpants. But remember, he's there 3 hours later, and this is the final point of rest for Todd Stermer, after he's been taken in this boat to here. So if you find in here, you have to analyze, could there have been a transfer to the boat, or you remember, Matheny put clothes on him, a bunch of clothes, and they found that here, right? Could there have been a contamination from there? It's not whether there was, it's whether he can rule out the logical possibility that there was. And how do you do that? You use the scientific method like all scientists do, like all professionals do, and you collect data, starting with the boat, working backwards. I asked him, did you use a rag, anything? No. Did you talk to anybody? No. Talk to the family? No. That's all data. No. I don't even think he knew there was a boat involved. So he couldn't collect the data, so he couldn't do the rest of the steps, so he couldn't comply with the scientific method, which means that his methodology is garbage, so any opinion that says that didn't matter, that's garbage too. If he didn't rule it out, that's reasonable doubt. These are 11 different things that I've come to. When you go back, you were taking a lot of notes, you might find more. When you think about all the evidence, you might think, let's look at that. Did he consider that? Maybe that's reasonable doubt. You might find more than I did. But you don't take possibilities. Pros don't take possibilities. So when Ms. Zuderveen, like Mr. Blair said, was it possible that this happened? That's not evidence. That's speculation. That's guesswork. Experts don't do that, and you can't accept that as valid evidence. Not only was there Mr. Leroy's shortcomings, but you remember a lot of the police witnesses who testified. Oh, let me segue here. Let me just back up just a little bit. Do you remember, all of a sudden, remember this fire chief who had been retired for a lot of years, and comes in, he said, I've done hundreds of fires. And all of a sudden he remembers, yeah, I smelled fuel too when I was there. He didn't write any report 18 years ago. He's never said that ever in any document. But he admitted, I met with the prosecutor, and we talked about what my testimony was going to be. So it's kind of weird that all of a sudden people 18 years later are saying things that they never said and never wrote. So when you consider credibility and the credibility of the witnesses as you're analyzing whether there's reasonable doubt, think about that. Every law enforcement person who came in and said that they smelled fuel at the scene on Todd Stermer never said it before and met with the prosecutor to prepare. One more thing I did forget. There was talk about the construction of the house. And this is real important because as you're analyzing, how could the fire have started? Could it have been an accident? Remember Brad Stermer, the older brother? He said, I was in college, and remember we had that yellow house that was my dad's, and Todd was the main guy working on it, and he said, I'm a handyman, and I'm good at it too, but we didn't have any money. I think the phrase was, we were scraping nickels together to get it fixed. And he admitted, we didn't use the best equipment, the best components as we were doing the house. And 5 months after they finished, with Todd at the helm, being unlicensed, that place burned. And he said that was an accidental fire. Well, that can happen when you don't have licensed contractors, and good as you may be as an amateur, you're not a licensed electrician, you're not a licensed mechanical person, HVAC, nothing. That can happen, and you can't rule out that that happened in this case, and we know why. Because it took, what, 6 years for this house to be built? You're scraping nickels if it takes 6 years to build a house. You're doing what you can when you can afford it. You heard, and maybe it's because of the horses, but you heard they were having money troubles. That's why they didn't build it. That's why they were scraping nickels. And he was at the helm. And you heard, not only did you hear from all the people who have been in the house about all the exposed wood, which is why it would have gone up so fast, because it was a tinderbox. Then you heard the last witness we had, Rich McGrew, who said if you don't get a final electrical and a final mechanical, and we don't certify it as good for final occupancy, it is a unsafe house. Why unsafe? Because you can have fires. So you're not here to supply evidence, you're here to address the evidence that was given to you. And in that sense, you can't rule out that because of poor construction, this could have been an accidental fire. And the fact is, because it's a tinder box, that also explains the speed of the fire. But at least Leroy was candid enough when I questioned him and caught him in some demonstrable untruths, that he said, yeah, I didn't know how the house was built. I didn't know that it had OSB flooring. I didn't know that there was no final certificate. I didn't know that it didn't have final inspections. That's all data that you can collect that's available. You know who collected it? Len McHugh, the property adjuster, who, by the way, Linda Stermer asked him, why are you here? Because we don't have insurance. We'll get to that in a second. But he's the one who collected the available data, he said, from the building department, which is what Leroy could have done, but chose not to. Garbage in equals garbage out, makes it unreliable. It can't be trusted. And if it can't be trusted, that's reasonable doubt. Now, let's talk about the police work in this case. In this rush to judgment, where they first, I will say, they got misled by Leroy, who called it an incendiary fire. So in their terms, in police terms, that's an arson. And we have a guy who's dead and we have blood on the bumper. Now, their rush to judgment resulted in all kinds of sloppy work. First of all, this missing video that we're talking about, which would have helped anybody, including a defendant who's under arrest, determine how the fires was spreading, that's gone. You heard Cynthia DeLoach, the gas station attendant. I asked Maciaski, you got the cash register tape and the video from the place in February of '07, a few weeks after. It's stuck in your drawer for 2.5 years. And is that proper protocol for property preservation? I'm not sure what the protocol was back then. You're a veteran cop. Your command staff. You don't know this? Or is this just another half-truth? Mislabeled evidence. Remember that coat that was in the silver can that turned out to be Mike Matheny's coat, that red checkered one? That was labeled Todd Stermer, which helped Leroy determine, well, everything that's tested positive for gasoline is Todd Stermer's. Therefore, couldn't be any contamination. He didn't realize until later, oh, that's Matheny's coat. And he didn't rule out the contamination from Matheny's coat or the boat. If he didn't rule that out, that's reasonable doubt. Witnesses weren't interviewed for 2.5 years. Cynthia DeLoach didn't get interviewed until 2.5 years later, June of 2009. And remember the testimony from her? I knew Deputy so-and-so, and he'd come in all the time. Have you talked to the folks? Have you talked to my bosses, whoever's running the investigation? No, nobody's come to talk to me. Remember Maciaski, who said, I got too busy and I forgot. Everybody seems to forget here. He got too busy. He didn't go see her for 2.5 years. When you look at it with a bit of a jaundiced eye, this other detective, if he's going to Cynthia DeLoach, what'd she say, every month, every 2 months or so, have you talked to us? Have you talked to our guy? Have you talked to our guy? You think he's not going back to the department? Why don't you talk to this woman? She's got evidence. He didn't do it. And by that time, she forgets, because you heard her testify. I don't know if Linda Stermer was pouring gas. I didn't know, she said, I think she was, but I didn't see a container. Now, think about this, because I want to talk about this red gas can that was found in the front yard. And they're trying to relate it, one to the fire and all the way back to Cynthia DeLoach. This gas can that was found by Leroy, you can see, has a broken spout. He didn't know how long it had been there. This gas can, to try to relate to and make this big conspiracy by Linda Stermer, she went and bought gas in the morning, and she put gas in the truck. Linda Stermer is all about 5'6". Chevy Blazer, remember the talk was the hatchback. 5'6" woman doing this into a gas can, and you didn't spill a drop of gas. You didn't spill any gas. You didn't get it on your clothes. You didn't get it on your hand. How do you pump $11 of gas, roughly 4.5 gallons, into a 1-gallon tank? You don't, because there was never any gas being pumped into a gas tank. And how do we know that? Because Trevor was honest enough when he testified to say, remember when we went to the mall in the Blazer? I didn't smell any foul smell. You know what gas smells like, right, Trevor? Yeah, I know what it smells like. You didn't smell anything, did you? No. Anybody, including me, when it's time to use a snowblower and I gotta go to the gas station with my gas can, I put it in the truck of the SUV, it smells. And I may not spill the drop. But anybody who spilled gas on clothes or their hands, it reeks. For a while. So when you think about credibility and what is trying to be portrayed as this grand scheme, reasonable doubt. Was this even connected? No. The most telling evidence is their expert, Leroy, said, I have no idea. It has anything to do with it. So what you're being told by the prosecutor is some theory based on no evidence, trying to connect dots. But it's a bridge too far, a road too long. You can't connect dots because all you're doing is guessing. And you as a jury have to evaluate the evidence, not the talk of me, not the talk of Ms. Zuderveen. Judge will tell you that. What we say is not evidence. What they said was evidence. Leroy said, no idea. No idea. Now, we have all kinds of reasonable doubt, at least 11 things, just in terms of how the fire started or where the fire started. But now I want to talk about the second part of it, intent. Did Linda Stermer intend to set a fire? Let's look at the objective evidence. Then we're going to talk about all these 5 ways that Ms. Zuderveen said Linda Stermer tried to kill her husband that day. 5 different ways, and we'll analyze that against the objective evidence we have. First, the thought and the theory by the prosecutor is Ms. Stermer struck Todd in the van, therefore she intended to kill him. Well, let's look at that through reason and common sense. And if you lack confidence by using your reason and common sense, that's reasonable doubt. You heard the 911 tape.
Is there anybody inside? Is there? Oh my God!
That, as you know, is Connie Calhoun, and you saw her stress level, the chaos she was going through. She wasn't in a fire. Her spouse wasn't on fire. Her house wasn't on fire. And you saw how she was. And by the way, every person who testified here from law enforcement or people like Connie Calhoun and Mike Matheny and Dr. Masali all testified she was hysterical. She was beside herself. Now, she would have to be the greatest actress in the history of Hollywood. Meryl Streep would have nothing on her. And by the way, remember the theory that Ms. Zuderveen just told you? She was driving down the driveway. She was escaping. Let's look at that through reason and common sense and see if we doubt that statement. Who is a mastermind who supposedly got gas in the morning in a gas can to torch a place, scooted the kids out, and then is escaping, as she said, and escaping with no shoes, and escaping with no coat in January, and is escaping with no cell phones in January, and is beside herself hysterical? All it takes is a little bit of doubt based on reason and common sense. And anybody who heard that 911 call cannot come to any conclusion other than she was shocked by the fire and she was in a state of panic. And you heard Bob Trenkle. Firefighters, police officers, military folks, they train so they can have muscle memory when the stuff hits the fan. She's a middle-aged woman who never engaged in any of that. And she acted like it, like she lost her mind, because it's fight or flight. And she ran, but she wasn't escaping. She was trying to get help. And it is pretty darn cynical to listen to that 911 call and to say she was trying to escape this mastermind was. Now, there were talk about valuables in the house. One of the things you look at, as any cynical person like Willison would be, is if you're going to torch your house, I want to make sure my pictures of my kids and all my valuable stuff and all my guns and everything else are out of there. Then I'll torch the house. Remember, Trevor's baseball cards that were so valuable to him were found in the basement in the rubble. And you heard from Tina, Benny, and she said, my husband and I, we had this handmade little sifter, and we found a wedding ring, Linda's mom's wedding ring, valuables that were in the rubble, by using equipment that Scott Leroy should have been using, that he has, that they use. So this idea of you hide valuables, reason and common sense. And reason and common sense tells you if you have a financial motive, you kind of know you had insurance. Len McHugh said, she asked me, why are you here? We don't have insurance, our insurance lapsed. This is the financial motive? This is a get rich quick scheme by this mastermind? There's no intent. There's reasonable doubt as to every bit of intent here. Oh, then let's talk about these 5 ways, the 5 best ways to kill your husband in the same day. First, she tried to drug him, then set a fire. Where'd that come from? Kate Fox with a coffee cup, remember? But Kate Fox told us, Linda Stermer said, I put the coffee cup and I didn't drug him because he was already on tranquilizers. Let's look at the objective evidence about that. Dr. Markey told us in no uncertain terms that there are no drugs in the system. And when we talk about who's being square with you and we want to have credibility, Dr. Markey said the remnants, the metabolites of hydrocodone were in the urine. That's not active. There was nothing but caffeine in the bloodstream, the active ingredients. And the metabolites that are in the urine, which last longer, were explained by the medical records that we just admitted today from the family physician who prescribed Entex HC, a narcotic for his ear infection that has hydrocodone. Dr. Markey admitted hydrocodone is consistent with taking this cold medicine that the doctor prescribed. So when we're talking about what the evidence represents, like I said, thank God what we say is not evidence. You can rely on your notes and you can rely on the transcripts. Well, you can't rely on it, I can. And also, Ms. Stermer said that Dr. Markey had no opinion as to whether the skull injuries, the lacerations on the head, were related to the van versus something else, which you're suggesting is a frying pan. Dr. Markey said on page 18 in his testimony, those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it? Well, the injuries themselves, as I stated before, very well it could be to being struck and overrun and striking things on the undercarriage of the motor vehicle. That's his actual words, not what you heard he said. And you can look at your notes, because these are the actual words under oath. And it's consistent with Dr. Zacheski, I just call him Dr. Z, who is a renowned biomechanics injury mechanism expert with decades of experience working with brain injuries, who told you all of the lacerations and these skull fractures. It sounds bad, a skull fracture. A depressed skull fracture has been explained as you take your finger through some icing on a cake. It doesn't even hit the bottom of the bone. There's no linear skull fracture. There was no brain injury, as Ms. Zuderveen tried to suggest, Markey said. That's not on the autopsy. These are AIS-2 injuries, Dr. Z said. Moderate injuries. Not related, there's no evidence that it was related to a frying pan. So that's the first one, drugs, set them on fire. Number two, crack them with a frying pan, then set them on fire. Except that came from Dardita Gordon, who admitted to so much mental illness and on so many medications normally that she would have been, except she was in jail when she gave that statement. And she said, they don't give me my meds in jail, and I have memory problems. And guess what? She admitted that it was Detective Macioski who suggested, could it have been a frying pan? It was a jailhouse snitch. Yeah, I guess it could have. You look at all of this with a cynical eye, and when you're evaluating the witness's credibility, that's unreliable. That's not consistent with the physical evidence. We don't have to prove anything to you, but we bring you objective evidence, follow the science, follow the objective evidence, and you can't come to any other result other than there's reasonable doubt. And by the way, what devious mastermind who's going to torch the place and kill her husband spends the afternoon packing up Christmas decorations? What, an hour before I'm going to torch my place and kill my husband? None of this makes sense. Starting with all these witnesses who prepped with the prosecutor and all of a sudden change their testimony or hear new testimony. So frying pan is number two. Setting the fire by itself, well, we already talked about that. That's clearly reasonable doubt as to where the fire started, no doubt as to Linda Stermer didn't have anything to do with it, and you didn't hear a single word from Mr. Leroy or the prosecutor that gas on the sweatpants had anything to do with Linda Stermer. Because if they had that opinion, it would have been front and center. It would have been blown up on the wall 10 feet high. No opinion, your notes, you can pull them all. Nobody will find a note that says that. The gas on his pants, which he claims is the whole key to the case, that it had anything to do with Linda Stermer. 4, run them over after you set the fire. Well, you heard testimony from Dr. Z that it's a 5-mile-an-hour impact. And those injuries, you didn't see anything where he was run over by a 4,500-pound vehicle, no broken legs, no broken bones, rib fractures consistent with CPR, no brain injury, no skull injury, no nothing other than icing on the cake and some lacerations consistent with being run over at a low speed, as Dr. Z said, with a high load. High load is just, it's 4,500-pound van. And Dr. Z's testimony is undisputed, because don't you think with the resources that the government has, if they could find anybody, and I mean anybody, to counter Dr. Z or counter Dr. Markey, that they would have? But this is the same group that's letting Leroy defend himself. They won't even hire Shinsky, because Shinsky's not going to go their way. And finally, the 5th way she tried to kill him that day was to suffocate him. So here she is in this panic state of chaos, fight and flight, and out of her mind, and she's yelling, "Todd, Todd, stay with me." And what do they say? We think she was laying on top of him. She wasn't laying on top of him. She was trying to hold her husband and keep him alive. And if there's any little doubt that you have that's supported by reason and common sense, that doesn't require you to abandon reason, then that's reasonable doubt. And if there's reasonable doubt, you have to vote not guilty. There's no intent here. Clearly reasonable doubt as to the intent and lack thereof. I'm going to talk a little bit about the inconsistencies, and of course, there were a lot. But you know what they were? They were details after she got to the top of the stairs, when her world blew up. While she was downstairs and calm, everything's consistent. I'm in the laundry room, and Todd is upstairs, and that was relied upon by Leroy in terms of finding the area of origin. It corroborated his physical findings. His physical findings corroborated her testimony. Nothing about these witnesses that they're bringing you is being corroborated. We talked about how Mr. Trinkle said how people train so they hope they can combat panic when the adrenaline is high in a stressful situation. And when you're in the jury room, I want you to think of this. A lot of people Monday morning quarterback and go, I wouldn't have done that. I would have jumped on my husband. I would have saved him. While you're having a cup of coffee in the jury room, or you're watching TV in 2020, I would have done this, I would have done that. You don't know what you would have done. What you would have done and what you could do in the situation are two vastly different things. So when you're thinking about what she was going through, you have to put it through the lens of this high burden, this presumption of innocence, and that none of us know, unless you've been in a fire and running out in your underwear, what people go through. I'll talk a little bit about their witnesses, not much, frankly. Certainly not going to go through every witness of theirs. Let's talk about, we talked about Dardita Gordon. Let's talk about Kathy Ilge, who's the one who said that she talked to me about the coffee cup and the drugs, and that she found jewelry in the van, Linda Stermer's van that she drove, remember, within a week or two of the fire. And in the center console was jewelry, which to a cynic would mean you're kind of squirreling away stuff, the valuables, because you don't want them to burn up in the fire. Well, look at the objective evidence in this case. First of all, you remember Kathy said within 2 weeks of this "I'm in the van." And in the center console is the jewelry. Do you remember the van was confiscated by search warrant that night and examined the next day? The picture of the center of the console of the van, as Maciaski showed, taken on the 8th the next day, there's no jewelry. And Maciaski, who's supposed to put a detailed report together anytime you do a search warrant, it's the property you take and confiscate and take into evidence, never mentioned jewelry because it didn't exist. And here's the kicker. This is a murder investigation. What police department in a murder investigation involving a bloody van is giving the key evidence back to the family in a week? Think about that. When you're back in the jury room and you're thinking about the credibility of these witnesses, no police department. This is a murder investigation, and that is a critical piece of evidence. You don't give it back to the family. Oh, the other funny thing, among many, is that she said, let's strike that. I'm going to go to Kate Fox. But Kathy Ilg can't be believed. Testimony is unreliable. And for them to put somebody who would talk that crazy and that to give testimony that is so demonstrably false by the evidence, you have to wonder as you start to think about these weird things, why are they putting up these witnesses to talk about things that would be impossible, that are demonstrated to be impossible? Maybe because they can't talk about the fire. Maybe they want you to dislike her so much you ignore that there's no evidence of a fire being caused intentionally. And nobody can prove it, so we want you to dislike her. We don't want you to think highly of her. She had an affair. She said this, she said that. She treated Todd badly. Because we don't want, in 90 minutes, they talked 5 minutes about the fire. Why we're here. And in the 5 minutes, you heard one sentence. Leroy said, it's consistent with an intentional fire. She didn't tell you about the evidence that supported that. She didn't tell you that we don't know how the fire started. We want to give you the why. We want to give you the motive. But we don't want to tell you how, because we can't. Let's talk about Kate Fox. Kate Fox came in here, dressed really nice, and talked about a coffee cup and the drugs. Remember, we talked about Dr. Markey, how he blew that apart. But the other thing that struck me is you were supposedly best friends with Linda Stermer, but because her sons lost their father and she had to take care of them, she had to switch a shift, you felt like she betrayed you? And so maybe you have an axe to grind. And when you look at her credibility, let's measure this against the credible evidence and the objective evidence. Linda Stermer, while she was carrying on this affair, told me to close up her post office box because her husband was going to find out. The federal government allows a stranger to come in and close somebody else's post office box? Really? They want you to believe that? This is who they're putting up as a credible witness to talk about she confessed, she did this. The objective evidence. When you're evaluating credibility, look at what's out there that can't be true. And finally, Trevor Stermer, Trent Stermer, they came on. They both disliked their mom very much. They both only started calling her Linda instead of Mom after she got charged in 2009. And they were both living with Grandma Stermer before the trial and after the trial. Just take that in consideration. I tried to be as nice as I could, but I had to point out all the inconsistent statements under oath, and it probably bored you because every 30 seconds I was going, remember you're under oath, right? And you swore to tell the truth, and you did tell the truth. And eventually, after you ask so many questions, they go, Yes, I was telling the truth when I said Mom was acting normal that day, which would be consistent with Mom's wrapping up the Christmas decorations and putting them away an hour or two before she's going to torch the place. You can't have it both ways. You can't have it both ways. You can't be this diabolical killer, master planner, so they can say that it's premeditation, and on the other side of the coin, you're saying she's going around wrapping up the Christmas decorations. And by the way, remember they said, not only was Mom acting normal, but if I'm going to torch the place, I'm not going to tell my sons, all right, see you when you get home. I'm going to say, don't come home for 5 hours. Or maybe you need to go to another friend's after you go to the mall. You don't say, just come home. I'll see you when you get home. That's not somebody who is premeditatingly going to murder her husband. And when you talk about, you're going to get a jury instruction about premeditation, it's going to be, there has to be some time connection involved with premeditation. Everybody has said a lot of things, maybe to their spouse, to their friends, or whatever, that they say in the heat of the moment, or tell their friends in the heat of the moment. But if this happened on January 7th, and she's telling Kate Fox this in the summertime before, that's not premeditation. That's not evidence of premeditation. There was no evidence of premeditation on January 7th. None. Talked about Chief Leach and all of a sudden his sudden memory. Oh, by the way, you do remember that Trevor and Trent also met with the prosecutor and all of a sudden remembered some things that they had never said before. Verge Franks, one of the police officers you saw first on the scene, smelled gas, but that's after Matheny's coat is on Todd Stermer. Didn't have a report, never said it before. I want to just kind of wrap it up this way. In order for them to obtain a guilty verdict, they have to show that the actions of Linda Stermer caused the death of Todd Stermer. The actions can only be she set the house on fire because he died of burn injuries. I was thinking about showing you the video of the burn of the sweat. You've seen it. You know what happens to polyester pants. And the question was, well, if he was on fire, how did the pants not burn since they burn so easily? And you heard Mr. Krenkel, who cited NFPA 921, chapter 24, that said, as we all know, well, we don't all know, but skin burns at about 110 degrees, 108 degrees. You get 108 degree temperature, your brain cells are burning and dying. Clothes, as it said in 921, ignition temperature, pretty much the lowest, is about 450 degrees. So that can explain the thermal burns, which he said, these were not contact burns. People who die in a fire when they've been immolated, they look like a burnt hot dog. That wasn't this case. This was thermal heat burns, which explains why the pants weren't burned, which also explains that there was no gas on the pants in any amount that could be related to anything with this fire. Because I wear my sweats Friday, Saturday, Sunday, Monday, it doesn't matter. People do that. You can't tell how long the sweats had gas on them, the last time they were washed, where he was. If he can't rule it out, it's reasonable doubt. And finally, I told you have rights. Linda Stermer has been fighting this since I've been with her for 6 years now. And Skip and our team. So now, excuse me, I'm going to turn her future to your hands. Follow the evidence, follow the scientific evidence, follow the objective evidence and understand how high the burden is to achieve beyond a reasonable doubt. Clear and convincing evidence, a firm and definite belief that any proposition is true is not good enough. If there is any doubt that's supported by reason and common sense, where you don't have to throw out reason, that's reasonable doubt. You deserve to be on a jury that holds the government to that burden that our founding fathers set forth. You deserve to be on a jury that holds the government to that high burden on every single fact that they need to show to prove those elements. They can't check a single box. Forget 3 boxes or whatever she was talking about. There's no evidence to suggest that this was an intentional fire. It was such a shoddy investigation by the fire sergeant, fire marshal, that there's nothing but reasonable doubt. People can't be 2 places at one time. And finally, they have to rule out reasonable doubt for every single element. You know why we're here, really? Is because Sergeant Leroy mailed it in. And 18 years ago, he destroyed Linda Stermer's life by mailing it in. So when you're deliberating and you have a conviction, and we said you took an oath to not mail it in. You took an oath, if you have a conviction, to stay as long as it takes and stand up and not be bullied by somebody who maybe wants to go home on Friday and doesn't want to come back because I missed 3 weeks of work already. There is too much at stake. A person's freedom is at stake. Don't mail it in. Todd Stermer mailed it in. Leroy mailed it in. And you know what? He not only did a disservice to Linda Stermer, but to Todd Stermer and to you. Return a verdict of not guilty on all counts. There's a verdict form that you're going to see. I didn't have a chance, we just got it this afternoon. Didn't have a chance to blow it up on a board. Possible verdicts. You may return only one verdict on each charge. Premeditated first-degree murder, not guilty. First box. 2, felony murder, the arson, not guilty. Everything depends on whether there was a fire that was set intentionally and was it set by Linda Stermer. If there's no arson, there's no crime. If there's no crime, there's no premeditation. Put this in your hands to do your job and hold yourselves to your oath. Thank you. Not guilty.